Hi everyone, it's Robert Kinsman with the Krause Kinsman Law Firm. Welcome to October. It's amazing that the fall season is already in front of us, and we're looking forward to getting things underway in court. That is the main update this month as we continue down the path of litigation. As I always start these videos, remember you're a client of Krause Kinsman. You retained us to represent you in your Camp Lejeune litigation case. So please make sure if anyone's contacting you, they're able to identify themselves as a staff member of ours, a paralegal, attorney, and is able to tell you what your case number is here at Krause Kinsman. They should be able to do that immediately upon you asking them. Again, thank you for hiring us to represent you in your claim. We've been working so hard to make sure that everything is in line for you to have a successful case. We know a lot of you have not had a wonderful medical experience in your life due to the water contamination of Camp Lejeune. So we hope we can at least give you some closure and give you a positive litigation experience as we move down the road. So recently the four judges in the Eastern District of North Carolina filed their order for schedule, also known as a scheduling order. In that scheduling order, it lays out basically the time frame of how the litigation is going to proceed and gives us point in times of things we need to hit in order to keep the case moving in a fair and efficient way. The first one is in the scheduling order is identifying bellwether plaintiffs. So what a bellwether plaintiff is somebody who likely or reasonably represents others with similar or the same illness. So we have to identify bellwether plaintiffs in the first 5 illnesses of the case that are going to move forward for discovery purposes. What is discovery? Discovery is the ability for us as plaintiff lawyers to review government documents. It's the ability for us to take depositions of government employees, both former and present. It's the ability to make sure we are proving your case, whether it be proving your case with medical records or proving your case with exposure, being at Camp Lejeune. And it's the ability for us to literally take potentially millions of documents and consolidate them into a package where we know what the playing field is in terms of what the government knew, when they knew it, when you were there, how you were there, why you were there, and your medical experiences therewith. We know the water there at Camp Lejeune was poisoned. There's no doubt about that. The government doesn't deny that the water was contaminated with various solvents that poisoned the bodies there at Camp Lejeune as they lived and breathed and bathed and swam and drank. So what we're really focused on is building a package to prove that water actually caused these various illnesses. So we have to prove that one or all of the solvents or some of the solvents actually can cause and does cause certain types of cancer or neurological issues or other various illnesses and diagnoses that each of you suffer from. So the judges selected 5 illnesses to go first. I don't want any of you to think that your illness isn't as important or your illness is never going to see the light of day in court. We have to start somewhere. So we have 5 illnesses to move forward for discovery. We'll pick individual bellwether plaintiffs in each of those illnesses to review their medical records and prove their case up as a way to prove the case up for all of you with the similar illnesses. Bellwether plaintiffs are representative of all of you that suffer from those types of diseases and illnesses. I won't go through the exact dates or time frames, but there will then be a selection of the next 5 illnesses, and then thereafter we'll select 5 more. And then at some point in time, we'll continue to select the illnesses to litigate and move forward. The judges have indicated there will be trials in 2024, so next year. That is very fast for large consolidated cases like this. The judges want to keep us honest, they want to keep us moving, they want to keep us efficient, and we appreciate that as well. We actually asked for trials to be in 2024. We know as a plaintiff's leadership in the Eastern District of North Carolina, appointed by the court, that we have a lot of work to do. We have to retain experts. We have to review documents. We have to get the documents. We have to go through motion practice against the government. So there are various things we can do to keep the fire going, for lack of a better term, in court to make sure that we are proving your case. These cases usually take a lot of time, but we are on a fast track, and we are on a fast track because we know you have all been waiting for a very long time for some type of justice and ultimately some type of closure. So there's not a day goes by where we're not doing something to move this case forward, whether it be obtaining records on your behalf or trying to get records from the government to prove this case. And we look forward to continuing to do that. As far as other things going on, some of you who are filing on behalf of deceased family members, we have been reaching out to talk about probate. Probate is where you have to open an estate for the decedent, the person who passed away as a result of the water contamination at Camp Lejeune, and somebody has to be named the administrator or representative of that estate. Some of you have already done that prior. Some of you did it 20 years ago, 10 years ago, 12 years ago, 2 years ago, 1 year ago, or are doing it right now. For those of you who have already opened the estate, we're going to be reaching out to you to see how we can reopen that exact estate. For others, we'll be opening a new estate or an ancillary estate. So be on the lookout if you're filing a claim on behalf of a loved one that's passed away. We have to go through some questions for you to know the best route for your case. Others of you may be falling in that quick pay option that the government came up with, and a lot of you probably have heard about it. The positives are it gives you a chance. For those of you with the 9 illnesses that the government is willing to pay on, it gives you a chance for closure and to put this all behind you. But I want you to remember that offer that the government came up with is one-sided. They didn't take any advice or recommendations from plaintiffs or plaintiff lawyers. They came up with their own process. They are only paying on one illness. So if you are suffering from multiple illnesses, let's say 2 or 3 different cancer types, they're only going to pay you for one. And also, they're not going to pay any enhancements. So if you went through years of treatment, had the cancer multiple times, if you're still suffering, if you have other illnesses related to that illness, or we have a client who had to have an amputation due to a cancer, they're not going to pay you for that in this quick pay option. The quick pay option is a quick settlement to get you off the books and to not fully compensate you in our belief. So I want you all to remember that. Also, if for those of you who may qualify for the quick pay option, the government has to actually make an offer to us for your claim. And we have not received an offer yet, but once they do, we'll certainly reach out to you. For those of you who don't fall in the 9 illnesses previously discussed in our last video, we're fighting. We're fighting in litigation. We're negotiating behind closed doors with the government. We think there's a path for you to succeed in this case. So do not be down. Do not want to give up. I know you come from families, of military families, that you never give up. So I want you to do that here. We're here for you. We're going to continue to work for you. And we're working for those who do fall in those 9 illnesses too. So be on the lookout for any communication from us. We're going to be reaching out just to say hello. to see if any of your contact information changed, to see if your medical history has changed, if you're seeing a new doctor, if you have a new diagnosis. Always be on the lookout for Krause Kinsman calling. But the main takeaway from this month's update is we are getting started in the court, and we have a scheduling order in place. We have time frames and deadlines to hit. We know illnesses that we're going to work up in litigation to start at least. We know trials are going to be in 2024. We've already asked the government for lots of discovery documents, asked them to answer various questions regarding Camp Lejeune, what they knew and when they knew it, and then also documents related to both your medical history and your exposure, where you lived there, why you were there, where you were there, and things like that. So all is well, all is moving forward. We couldn't be more excited about where we're headed. Some people ask if this is a roller coaster. A lot of our litigations are roller coasters, but because of who we're representing, we're going to remain steadfast. We're going to remain at the top of that hill, looking down, knowing that we're going to create something great for all of you. So please reach out to us, especially if you've opened an estate already for a loved one. We need to know that. We'll go through our questions with you, and we'll continue to file claims as we get more information from each and every one of you. And be on the lookout for all our correspondence. We do it by text, email, and phone calls. And importantly and lastly, if you have any type of medical conditions that have changed, or you have new diagnosis or illnesses, let us know. If you have new contact info, which would be email, address, phone number, please let us know. And we look forward to working with you and for you and on your behalf. So everyone have a wonderful October. I'm a Kansas City guy at heart. Go Chiefs. We look forward to speaking with you soon. Thanks.